Tēnā koutou katoa, ko Brad Morris toko ingoa, te ama kupua, te parenga te whare wananga Waikato, haere mai, te whare wananga Waikato. It's a great pleasure for me to launch, after Matu's mihi, to launch the annual Harkness Henry Lecture. This is the seminal event within the academic and intellectual life of the law school. Harkness Henry has been a partner of the law school since the very beginning, in part through the particular intervention of the founding dean, Professor Margaret Wilson, up in the back. This is like being in a law class here. Aidan Warren, Roxy, others sitting in the very back row. You can tell the troublesome students who hide back there with the beer bottle up there. You know, typical law school class here. But even some of the judges up in the second tier as well, so we notice these things. But no, we welcome you all. It's a very distinguished audience this evening. We're delighted, of course, to have you all here. For some, you are regular visitors. Some, of course, are staff and students within the University of Waikato. Some are the many jurists who regularly volunteer as coaches and mentors and judges in our wide variety of mooting programs and other competitions. And of course the staff of Harkness Henry, many of whom are here, and as I say, they've really been a tremendous supporter of the law school from the very beginning. Tonight we have the pleasure of having not only a distinguished judge of the High Court with us, but also a rather a unique, often insightful, invariably entertaining, and frequently provocative speaker in the form of Justice Joseph Williams. Justice Williams was appointed a judge of the High Court on 10 September 2008. Missed my birthday by a week. I'm quite forgiving him for that. Graduated from Victoria University of Wellington with an LLB in 1986. From the University of British Columbia with an LLM in Honours in 1988. More importantly, he broke the closet door at the foot of my stairs in 1987. So that's what I remember of those years for him. But he then joined and later became partner of the law firm of Kensington Swan. After then practicing with them, he established, was part of Walter Williams & Co. from 1994 to 95. Then he was appointed Chief Judge of the Maori Land Court in December 1999. Shortly thereafter, a Deputy Chairperson of the Waitangi Tribunal, while Sir Eddie Dury remained as Chair for a period of time. And then Justice Williams took on a role as Chairperson of the Waitangi Tribunal in 2004. He's a former Vice President of Tangaroa Maori Aotearoa, the Maori Law Society, a former President of Tirunanga Roya Tamaki Makaro, the Auckland Maori Lawyers Association, a Fellow of the International Academy of Trial Lawyers, Fellow of the Law Faculty of Victoria University of Wellington, just come back recently from teaching a week's intensive course at Stanford University, which he does each year. His iwi affiliations are Ngāti Pukenga and Aotearoa, Waitaha and Tapuika, and he's here kind of was on holidays, but has kind of managed to fit this in, having recently come back from overseas, but he quickly overcomes jet lag, and so he's gracing us with his presence here this evening. The title of his speech is Lex Aotearoa, a heroic attempt at mapping the Maori dimension in modern New Zealand law. Let me ask you all to give a very warm welcome to Justice Joseph Williams.
Tēnei te ara kairunga te ara olangi e tūnei te ara o papa e takoto nei. Tēnei te ara olangi rā ko papa e takoto nei. Kia rarau te tapu ai o tāne ki raro nau mai te pō tēnei te Aotearoa i Maori ora. Nō reira kei ngā langa tira kei roto i a koutou e matiu. Nā u tere o mihi kōrua ko Brad nā kōrua ngā mihi e o no ka mihi e mai te mihi e mihi anō te utu. Nō reira mihi mai whakatau mai. Mihi mai whakatau mai ki te āhuatanga ki ngā mate kakau e neia. Kei runga kei taku amo, kei runga kei taku tuara. Kia hatia tuku a rātau, kia haere rātau, kia rātau, tātau, kia tātau. Now that's timing. Your Honours, Dean, distinguished professors, students, counsel, partners at that great law firm, Harkness Henry, that has made this thing work for a very long time. Greetings to you all, and I'm so pleased you could come and spend what I hope will be a short period of time with me while I talk about this subject. I was hoping that I'd be Harkness Henry VIII. But apparently I'm Harkness Henry the 22nd. But that tells you what a distinguished institution this is. That it's been going for 22 years, and I looked at the list, I was provided with a list of people who'd given this lecture, and it is rather impressive. The Chief Justice, Sir Robin Cook, as he then was, Margaret Wilson, former Attorney General, a long, long list of distinguished and illustrious judges. And then Mrs. Williams's little boy, Joe. So I thought that I should come up with a title that would match the quality of my predecessors. Lex Aotearoa, a heroic attempt, pardon the grammar, I notice that grammar's poor, a heroic attempt to map the Māori dimension in modern New Zealand law. Turns out that was a mistake. One of the things I've learned out of this process, after the days and days I've ached about how to make this thing work, is that you should know about the content of what you're going to say before you stick a tag on it. And having chosen the tag first, I realised that the job is really hard. So I wrote heroic, but I think probably on reflection, the right name for this lecture is a vain attempt to map the Māori dimension in modern New Zealand law, and I mean that in both senses of that word. You see, doing this is full of risk. The biggest risk is that all I'd end up doing is tracking through Māori dimension law from the core Māori matters of Māori land, treaty settlements and so on, through to environmental law, family law, crime, IP, trademarks and patents, blah, 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 blah. And you would have a descriptive discussion that's a mile wide and an inch deep and boring. Or worse, I'd go through that process and discover that actually these various areas of general law with the Māori dimension in them are not connected at all. And there's no insight to be gained by trying to map this subject. So, on reflection, this title was full of risk. It just might not come off. And frankly, I'm still not sure whether it's going to come off. But so why would I do it? Well, as Brad indicated, 5 years ago, it seems like yesterday, 5 years ago I changed jobs from a career really focused on specific areas, lots of Māori focus, but in practice, environmental law and public law as well. From a long career as a specialist, I transited to being a generalist. And that taught me a whole lot of things. The great thing about being a High Court judge, I recommend it. It teaches you that the law is a holistic being. That it's a big, highly interconnected mechanism of social control. And shot through it in the 21st century is Māori stuff. Shot right through it. So the gain in this was to see if we'd got to a point now, in 2013, where you could say Māori law is actually a coherent body of law now. Not the specialist Māori areas, Māori land, Treaty of Waitangi settlements, and then all the Māori bits and all the other stuff, but actually a coherent body of law with its own underpinning, cohering principles and values. Now, why would you want to do that? Well, if you could find that mother lode, if you saw how these things were all connected, whether you're talking about patents or family group conferences, whether you're talking about the alienation of Māori land or criminal sentencing, then you could see much more clearly where this thing is going. Because one of the things that is clear is that in 2013 this process hasn't stopped. That's true, of course, of all law, but it's particularly true of this law. This law is in flux, in constant kind of roiling turmoil, it seems to me. So if we could find the underlying ideas in it, we could see where this ball is taking us. Maybe. Well, I'm not sure whether I've been able to do that. So here's my approach. When am I supposed to stop? Seems to me crucial that when you talk about modern New Zealand, the Māori dimension in modern New Zealand law, you start with the Māori dimension in historical New Zealand law. One of the mistakes of scholars, perhaps, looking at this particular area of the law is to decontextualise it, decouple it from its history. And in this game, in law particularly probably, but in Māori issues law in particular, history is everything. So, what I want to do is track through the history of Māori law. And I'm going to try and do it in 3 phases, and then maybe suggest some more. The first law is the one that arrived here about a millennium ago. What I call in this paper the law of Aotearoa. The one that Kupe brought and Toi brought on their waka. To understand that law, you have to understand the culture that these Hawaiians brought. And then understand how the land and the sea here changed that culture, melded it to find its place here. So Kupe's culture was at home, on land or sea. Its defining principle, its lifeblood, was kinship. In the Māori language, whanaungatanga. The value through which Kupe and his people expressed relationships with the elements of the physical world, the spiritual world, and each other. A crucial thing to understand. Kinship, not just interhuman kinship, but kinship with the physical world and kinship with the spiritual world. So the sea was not an impersonal thing, but an ancestor deity. The dots of land on which people lived were a manifestation of the tension between the deities. Kinship was a revolving door in this culture between human, physical, and spiritual realms, without any clear division. Ancestors spoke and interfered in daily life like a Greek tragedy. And the people traced their descent from the land itself. This culture had its own creation theories, its own science and technology, its own bodies of sacred and profane knowledge. They produced and distributed wealth and maintained social order according to the precepts of kinship or whanaungatanga. One of the things that the great anthropologists like Te Rangihiroa, Sir Peter Buck, said was that you have to understand that Kupe and Toi and all of the others came from different islands. They didn't come from one place, throughout eastern Polynesia. So the Maori circumstance after a couple of generations of living here was one of people who in spirit and mind belonged to different islands connected only by land. That explained their different dialects, the different approaches to law and social control. But there were underlying values, whanaungatanga the most important one, that they all carried with them. On top of whanaungatanga was mana, the source of rights and obligations of leadership, of tapu, a social control on behaviour as well as evidence of a divine presence, utu, the ethnic of constant obligations of reciprocity, and kaitiakitanga, the ethic of caring for your own. So these ideas, most particularly the kinship ethic, played out in the legal system. These people brought from Hawaii and then developed further here in a way that fitted the environment here. So land rights were obtained by consent. The term in Māori is take tupuna, right by descent. There's no word in Māori for ownership, but there is a word in Māori for source or right, and that's take. So right by descent was the primary basis of rights in land. You could obtain title by conquest, raupatu, or even by tuku, by transfer. But those rights were much weaker than the descent right of take tupuna. Resource use was also controlled by this kinship ideal. Many of you will have heard the story of Rata, who cut down the tree in the forest, the tōtara tree in the forest, in order to adze out a canoe, without going through the right procedures. And Tāne Mahuta and the denizens of the forest rebuilt the tree every night to teach Rata that he owed obligations to his kin, to the descendants of Tāne Mahuta. So that this was not just, kinship was not just about rights in resources, it was about how you went about using resources. The institution of muru, translated in the 19th century as plunder, what in Māori law might be said to be the combination of criminal and tort law, in which transgression of personal property would lead to a muru, is a great example of the kinship ethic in operation. Because if you transgressed, if you hurt somebody, stole something, breached a tapu, anything like that, you were not the person ultimately responsible. Your whānau was. So there was collective responsibility for transgression. And the whānau would have goods taxed from them. In a particularly egregious case, even land. And if the perpetrator was particularly important, it would become not just a whānau matter, but even a hapu matter. The crucial idea here was that this form of social control, what today would be called crime or tort, was a collective animal. Not individual responsibility, but group responsibility in terms of being the perpetrator, and group responsibility also in terms of the victim. And then there's the institution of whāngai, traditional adoption, still practiced today on a widespread basis. Unlike the Western version of adoption, by strangers primarily, the institution of whāngai was designed to strengthen the kinship net by sharing children amongst the whānau network, or even sometimes the hapu network. So at its core, this was a system which revered the fundamental ethic of maintaining good relationships. And the metaphor it used in the law and in its values to express that idea was whanaungatanga, relationship by blood. And even if you were not related by blood, the law would apply a metaphor to treat you as if you were. If you were a transferee of land in that tuku institution that I talked about, you would get the land, but you would be required to marry into the group in order to sustain your title. Without blending your DNA, your title would be lost the next generation. So kinship in the first law of Aotearoa was everything. Ideas of mana, utu, kaitiakitanga, and so on, followed on from and were in effect, I think, manifestations of that basic idea. I often say to American audiences that a Māori without kinship, without whakapapa, is like an American without a dollar. And it's literally true, because kinship was an economic as well as a social advantage. Your rights and obligations came from belonging to a kin network. Well, that system operated for 700 or 800 years before the second law came. Not the first law of Aotearoa, but the second law of New Zealand, the one you're familiar with. It arrives in the 19th century with the Industrial Revolution in full flight. The Restoration completed, the Glorious Revolution done, the King put in his box, Parliament kind of sovereign. The American Revolution done too, the French one. So it was a culture focused on the idea not of group, belonging and responsibility, but most particularly on the autonomy of the individual exercising free choice. If whanaungatanga was the mythology of the Maori system, the free individual was the core mythology of the second law of New Zealand. So relationships between humans were controlled primarily by contract, freely entered into between humans with capacity. And the relationship with the physical world was controlled primarily through the concept of property. As John Locke said, the whole point in law and government in the 19th century was the protection of property. So one system used blood relationship to express its relationship with physical resources. The other used the concept of property to express the same thing. In fact, this contractarian view of life even came to apply to the relationship between the subject and the state. These two systems came into collision, and the Treaty of Waitangi was the mediating instrument, at least at the beginning, between the law of Aotearoa and the law of New Zealand. Of course, as we know, it doesn't last in that role, at least not for the first while. It starts off as a solemn compact, but we Parata and the Bishop of Wellington by 1877 said, at least insofar as it purports to cede sovereignty, it must be regarded as a simple nullity. And the Crown must of necessity, the Chief Justice said, be the sole arbiter of its own justice. And that remained the orthodoxy for a good long while, but by 1941, in the famous case of Hoani Te Heuheu Tūkino and the Aotearoa District Māori Land Board, the Privy Council put that idea to one side, but nonetheless said the Treaty of Waitangi was not directly enforceable unless it had been incorporated into statute. So if it was created to mediate the collision, it didn't last too long in that role. What then about its content? Well, the interesting thing about the content of that document was, in the English text, you see the Lockean ideas being played out. In Article 2, the guarantee is the exclusive and undisturbed possession of your lands, forests and fisheries, as you may individually and collectively possess for as long as you wish to retain the same. Not an absolute guarantee of property, but pretty close. Carries all of those basic ideas of exclusive and undisturbed possession and the right to alienate. Core Lockean ideas about property. But the Māori text carried an entirely different set of ideas. It didn't talk about property at all. It talked about control. Te tino rangatiratanga o rātou whenua, o rātou kāinga me o rātou taonga katoa. The sovereignty over, the control over, the autonomy and respect of their lands, villages, and other precious possessions. I'm going to leap into the modern era and be ahistorical for a moment to talk about what happens to the treaty by the 1980s. By the 1980s, when Sir Robin Cook gets loose on Tūkino's case, he says, well, the Tūkino position is good law, quote, at least from a 1941 standpoint, end quote. And suddenly the treaty becomes a document of ambiguity, in which there is some possibility of it reassuming its mediation role between the law of Aotearoa and the law of New Zealand. A more subtle influence, the radio assets case decided by Justice McGeechan, suggests that even where the treaty isn't explicitly referred to in statute, it can be read in, as long as there's nothing particularly excluding it. The Huakina Development Trust case says, well, the discretion in the Water and Soil Conservation Act is wide enough to read the treaty in. Why not? Essentially, Justice Chilwell says, why not? And Justice Gallen and Goddard, Justices Gallen and Goddard say in the Barton Prescott case, in the area of family law governed by statute, the treaty's got to be there. So the treaty is no longer a simple nullity, but we're actually not quite sure what it is. It's something else. It's not quite the compulsory mediator between the two legal systems that we thought it was designed to be in 1840. It's something in between nullity and that. And in 2007, the Court of Appeal in the New Zealand Māori Council case number 20, whatever it is, Justice O'Regan sets out in obiter what he considers to be the limit of the treaty's role on behalf of the court. Two roles. It can be implied, it can be impliedly relevant in judicial review proceedings, and it can be an aid to statutory interpretation. But he says it cannot be sued upon in its own right. It cannot be the foundation of a private action in its own right. And that apparently was to be the end of the debate, except that on appeal to the Supreme Court issued a minute to say all parties agree that that statement by the Court of Appeal is in obiter. So there's still room for argument here about what the role of that treaty is between the compulsory arbiter between those two laws and nullity. And we still don't know what the last word is. Matthew Palmer offers a realist's note of caution in his book, where he says, well, you can get tied up in this legal status debate, but look at its practical effect in the operation of government. its effect on policy, the fact that it's contained in the Cabinet Manual as a risk to be managed in the public sector. Look at it as a quasi or perhaps extra-legal instrument affecting everyday government in this country. On the other hand, it has multiple definers. The courts define what the treaty says as well as its status. The executive, through Cabinet, offers its view as to what the treaty says. The Waitangi Tribunal does the same. And he complains it's a muddle, it's a mess, but no one is prepared to commit to trying to unravel it and tidy it. Well, there's a constitutional review going on now, and I'm not sure where that's going to go, but it's going on now, and it's undoubtedly going to address some of these issues. But I said that the two sides of the treaty in terms of the guarantees to the Maori side were property and control. Exclusive and undisturbed possession, and tino rangatiratanga. But what happened in the 1980s was that document morphed, started to perform a different role in terms of the content of its promises and undertakings. So the Court of Appeal in the Lands case says the core idea in the treaty is not those detailed words, but the idea of partnership. Partnership between the Crown and Māori, and even partnership between the races. It was analogous, created obligations analogous to fiduciary obligations. It created procedural and mutual obligations of cooperation. Well, those ideas are unique to this country's experience. If you look at the way the law develops in the US and in Canada in particular, where the focus is on the Crown's fiduciary obligation in Canada, and in the US on the federal trust obligation towards Indian nations, you see that the metaphor that's being adopted in New Zealand is a much more equalised one, a much more negotiated one in which both sides appear to exercise power. The powerless, powerful metaphor used in Canada and the US is actively rejected in what I think is, in the Indigenous context, a unique model. So it has very different content to that was contained in the original wording, but it's still playing the same role. It's still mediating the collision between the first law and the second law. Two other things I want to talk about in the context of that second law period. One is the idea of native title, I'll be quick on that, and the other is the idea of the place of custom law. A great deal of litigation over the status of native title during the 19th and early 20th century period in this country. Paul McHugh and Mark Hickford, the leading writers in this subject area now, both now say this was a highly contested idea. Whether Māori did have legally enforceable rights in land was a highly contested idea. The Queen and Simons in 1847 said yes. Parata and the Bishop of Wellington in 1877 said not even a phrase in a statute can call into existence something that just doesn't exist. And custom in respect of land doesn't exist, he said. There's Tamihana Korokai, covering the title to beds of lakes. There's Inri, the 90-mile beach, covering foreshore and seabed. There's Inri, the bed of the Wanganui River, covering riverbeds. Before we come, in the 21st century, to the famous case of Ngāti Apa, the foreshore and seabed case in 2004. There the court tidies up the margins and says whatever the ups and downs of recognition in the 19th century, there is a clear line of continuity and native title is enforceable directly. And in that they follow the early New Zealand cases, early American and Canadian cases, and they reach over to Australia, follow Mabo, they reach over to Canada and follow Delgamuuk and Sparrow in saying this is part of a grand lattice work of imperial law, of continuous recognition of native title. So by the 21st century, New Zealand has lined up entirely with the modern empire in terms of the recognition of native title. But what about custom? What about that first law? What status did that have? What status does that have? Well, Article 2, of course, guarantees this autonomy. So implicit in that guarantee is some sort of recognition of custom, of Māori custom, of tikanga Māori, what I have called the first law of Aotearoa. And that law was, of course, recognised statutorily and in ordinances right through the 19th century. In 1840, an ordinance was passed saying Māori on Māori crime was not to be tried in Her Majesty's courts, but to be left to the Māoris. Māori on Pākehā crime could be tried in the courts, but the sentence, the penalty, would be muru, 4 times the value of the loss of the goods. 1846, the resident magistrate system is introduced, in which 2 chiefs and a Pākehā judge sit in criminal jurisdiction. But the answers, the verdicts, must be unanimous. And custom continues. Of course, most importantly, by 1865 and the creation of the Native Land Court, Māori custom becomes the key way in which land is allocated, individual rights in land is allocated through the Native Land Court process. But a New Zealand court never really dealt with the question of enforceable freestanding custom until the case of James Takamore in 2011. And the question of who had the right to bury him, his hapu or his Pākehā wife, the executor under the will. The Court of Appeal pointed to the old reception cases, the case of Tanistry, Campbell and Hall, and applied the standard tests. Has there been an extinguishment of the custom? Answer no. Has there been continuity of the custom? Answer yes. Is the custom reasonable and consistent with the values of the common law? Answer no. You can't have might as right and snatch bodies. So the custom is unenforceable. The matter goes to the Supreme Court, and the Supreme Court takes a completely different approach. Doesn't apply the old tests at all. In fact, just ignores them. The Chief Justice says, this: the values and cultural precepts important in New Zealand society must be weighed in the common law method used by the court in exercising its inherent jurisdiction according to their materiality in the particular case. That accords with the basis on which the common law was introduced in New Zealand, only, quote, so far as applicable to the circumstances of the colony, unquote. Māori custom according to tikanga is therefore part of the values of the New Zealand common law. But she says, as in all cases where custom or values are invoked, the law can't give effect to custom or values which are contrary to statute or to fundamental principles and policies of the law. So almost without applying any of the old tests, Māori custom is in as a flavour on the common law, not a standalone enforceable thing in its own right, but as a spice to or a flavour of the common law. The majority, the decision of Justice McGrath, says no, it's not for the courts to make the decision, applying custom if appropriate, flavouring the common law with custom if appropriate, it's for the executor to make the decision. But the executor has to take into account custom. This is how he said it. The common law is not displaced when the deceased is of Māori descent and the whānau invokes the tikanga concerning customary burial practices, as has happened in this case. Rather, the common law of New Zealand requires reference to tikanga, along with other cultural, spiritual and religious values, and all other circumstances of the case, as matters that must form part of the evaluation. So this is an interesting development. A similar approach in the private law sphere to that taken by Justice O'Regan in respect of the treaty. In this case, custom law is a relevant consideration for the executor. It's part of the flavour. Under the Chief Justice's approach, it's part of the flavour of the decision of the law that the judge must use on her approach to make the decision. Much broader impact, if you think about it, than the orthodox tests in Campbell and Hall and Tanistry and so on. Continuity is just assumed without evidence. Extinguishment is not even addressed. It's simply considered that tikanga Māori is a part of the common law as a flavour. Part of business as usual in New Zealand law. But, highly conditionalised and easily defeasible. Just like the treaty jurisprudence. So, let me cut back to history. I've gone through the treaty itself, native title, and custom, freestanding. Let's go back to the history. In the 19th century, the second law of New Zealand recognised both custom and native title, refused to recognise the enforceability of the treaty, but did recognise custom and native title, not as matters of common law, but as positive statutory requirements in the Native Land Act. It recognised those things only in order to extinguish them. The point was recognition for extinguishment. And of course, over a 30 or 40 year period from 1865 to the turn of the 20th century, that project was extraordinarily successful. So that by 1910, about 10% of the country remained in Māori hands. Through Crown purchases it was lost, through war and confiscation in the 1860s, and ultimately through what Sir Hugh Kāwharu called that engine, that veritable engine of destruction, the Native Land Court, the court I used to head as Chief Judge. At the end of that period, I think it's fair to say the Māori world loses confidence and its own sense of cohesion. But all three of those things, the treaty, native title and custom, by the 1980s spring back into life in some form. So that if we are mapping this thing, we're not talking about a two-dimensional map at all. So far we're talking about two layers with some parts of the bottom layer growing up through and bubbling to the surface of the second layer. So you're talking about a moving system, not a static two-dimensional picture. And that brings me to what I call the third law of Aotearoa, New Zealand. The first law was the law of Aotearoa, the second law was the law of New Zealand, and the third law is the law of Aotearoa, New Zealand. The first law survives the collision. And through the 70s, picking up on I suspect the US civil rights movement, but more importantly, the rise in the Māori demographic, the huge bubble of Māori baby boomers growing up in the cities. Changes occur, and as is typical in the New Zealand context, they don't start in the courts. The courts are usually the last place at which these social changes are picked up. They start in legislation first, and the courts follow. The Treaty of Waitangi Act 1975 creates the Waitangi Tribunal, and you know the story from there. I'm not going to talk about that, although it's probably the subject. The work of the Waitangi Tribunal is a subject I know most about, but two big early areas I think are really instructive about where this system is growing and going. Changes in the environment, in environmental regulation, and changes in family law. Areas of high focus in the first law of Aotearoa because of the kinship principle. Māori were particularly focused on law change in the family area and particularly focused in law change in the environmental area because of the sense of kinship being core Māori values in both areas. These legislative changes are occurring at the same time as the courts are issuing judgments such as the Lands case in 1987, the famous Lands case, Tom Te Wehi's case, the first fisheries win for Tom Te Wehi, and so on. All being driven off legislation though. In Te Wehi's case, section 88.2 of the Fisheries Act, and in the Lands case, section 9 of the State-Owned Enterprises Act. So what we saw throughout the decade of the 1980s and early 1990s is, when you think about it, a grand conversation going on between the iwi, the courts, and the legislature, in a kind of churning and reaffirming engagement among them. The courts picking up sections provided by legislation in litigation being driven by Māori interests. And so it was in the environmental area. Two big pre-RMA cases, Habgood and Huakina, did two things. One, they said that Māori connection to ancestral land is not about Māori freehold land, but about all land in which there is a Māori ancestral connection, making, because of section 31G of the Town and Country Planning Act, that issue applicable across the entire 66 million acres of the country in land use planning terms. And Huakina, as I mentioned earlier, saying that the treaty is relevant in water rights allocation. A case about runoff from dairy farms on the Waikato River, actually. So all of a sudden, by the middle of the 80s, Māori connection to the environment is applicable across the board in water and in land. What follows from that is probably the grandest conversation of them all, in my view, the conversation that leads to the enactment of the Resource Management Act 1991, in which for the first time Māori issues are integrated into the way the legislation is to work. Section 6E, requiring recognition, what's the phrase? Requiring deciders to recognise and provide for Māori relationships with ancestral land, sites, waters, wāhi, tapu and other taonga. Section 7A, requiring particular regard to be had to kaitiakitanga, the ethic of stewardship. And Section 8, requiring the Treaty of Waitangi to be taken account of. All in Part 2 of the Act, albeit subordinate to the overall purpose of the Act of sustainable management. But on top of that, the Act contained a whole series of mechanisms and structures that could drive those Māori issues provisions into operation. Section 33 and the delegation powers. Powers could be delegated to tribes to make resource management decisions themselves. Heritage Protection Act provisions, where iwi could be heritage protection authorities, and iwi management planning provisions that provided for iwi to draft their own iwi management plans, and they would be relevant in the process of environmental decision making. The first really comprehensive treatment of the subject in which Māori issues were present at every layer. Well, how did it go? Up and down. I was going to go through a couple of cases, but I see I don't really have time. So, two things to look for. One is the Environment Court and judges in the appellate courts really struggling with the whole idea of cultural difference. Struggling with the Whanganui River tribes' issues over the reconsenting of the Tongariro Power Development Scheme. Struggling with ideas of taniwha, central ideas in kaitiakitanga values, but very strange to judges not educated in these matters. Struggling with the idea of what's a wāhi tapu and what is not. But actually struggling. And that's the important thing. Not always getting it right, and occasionally manifesting a degree of skepticism that comes from Western secular ideas. But nonetheless, struggling with these things and trying to make sense of them. The biggest problem with the Resource Management Act is the failure of the mechanisms to take effect. Section 33, the delegation power, has never been used. In 22 years of the Act's operation, never used. The partnership provisions in Section 36B never used once, I understand. No iwi has ever been made a heritage protection authority, even though the Act provides for that. And that appears to reflect the lack of will in local authority to make these provisions work. But what's happening is that slack is being taken up in Wellington, in the treaty settlement process. And tribes are negotiating changes to the regime through their own settlement legislation. The biggest and most famous example, of course, is the Waikato River legislation, providing for joint administration and policy setting over rights allocation in the Waikato River. So it can't be said that the Resource Management Act is an unqualified success. A clear advance, but significant shortcomings both in the will of the players, in the skill of the players, and in the usefulness of the mechanisms. What about family law? Well, the Children and Young Persons and Their Families Act reinsert whānau hapu and iwi into family regulation, into whānau regulation, for the first time since forever. Required to participate in decisions, judges required to work to maintain whānau hapu and iwi connections and to encourage the stability of those institutions in the decisions they make in respect of the care and protection of children. All subject to the Section 6 override, the paramount interest of the child. There are many who say there's a tension there between the interest of the wider kin group and the individual interests of the child. Perhaps. There needn't be if the whanaungatanga ethic is understood, but generally speaking, the impression I get from reading through the cases is that tension remains there, the tension inherent in the first law and the second law between the individual and the collective. Crucially, the 1989 Act introduces this great mechanism, the Family Group Conference, generally seen, as far as I can see, as a widespread success. Its success in terms of the first law of Aotearoa is that it moves the whānau back to the centre of decision making over children from within the whānau. Kind of an obvious thing really, but for a century the whānau has not been the decision maker. It has had no ability to allocate economic rights and no ability to allocate social obligations. All of those roles been taken over by other institutions. In the Children, Young Person, Their Families Act, the whānau is put back in the centre in a practical mechanism that it seems to me is working. The Care of Children Act doesn't seem to do quite that much. It doesn't have a family group conference provision. It focuses on the paramountcy of the child's interest in a much stronger fashion than the 1989 Act does. The Adoption Act seems to be almost antediluvian, focused primarily on stranger adoption, completely inconsistent with the institution of whāngai in the Maori world. So unlike RMA, where you can say there are comprehensive structures available and a genuine attempt to grapple with these issues, family law appears surprisingly, thinking about it, surprisingly to be a real mixed bag. The Children, Young Person, Their Families Act, powerful and working, it seems to me to be working reasonably well. But in the Care of Children Act, tikanga is much less prevalent and doesn't appear to be included in the systems in the same way. Compare that with the way RMA is developing now, where transfer of decision-making and regulatory powers to iwi is starting to creep into the system through the treaty settlement process. That doesn't seem to be the case with family law at all. Rather a troubling insight, it seems to me, given the importance of family law. What about crime? Well, the recent decision of Justice Heath up the back there in Mason and the Queen makes it clear there's no room for an alternative criminal justice process in the case of crime. The Crimes Act excludes everything else. It crowds out any area that could be taken up by custom. But he makes the point that there's lots of room in the sentencing area. He said the finding that a parallel customary system is precluded by statute in the verdict finding process does not exclude the possibility of custom playing a meaningful role in criminal proceedings, provided it can be accommodated within the existing statutory system. Indeed, where both offender and victim are Māori and there's no issue as to guilt, those processes may be more appropriate to address the needs of those directly involved in the offending. Leaving to one side the distinct interest, he said, and we'll pick up on this point later, leaving to one side the distinct interest of the community in the imposition of a sentence that adequately marks the offending. So be careful about the wider community that's watching, but there's room here for custom to play a part. The more serious the crime, the less room, he says. Well, judicial policy in this area has been pretty innovative in the last few years. We've seen the development of the rangatahi courts, parallel youth court systems, providing kaumātua, Māori protocols in operation, mihi being used, whānau engaged, the judge hongiing the offender at the end of each appearance, all of these things very familiar to marae contexts. And reaction appears to be very positive, both from the Māori community, from victim groups, and from the judges themselves. Yet the court's role is highly conditionalised. It's only in the narrow area of the youth court, and only when the victim agrees, not otherwise. The Matariki court operates in Kaikohe, the baby of the late Chief Judge Russell Johnson, who was looking for a model of a sentencing court that would work in heartland tribal areas, Kaikohe being a great example. He called those Section 27 courts. Under Section 27 of the Sentencing Act, the court can receive reports about background and culture of offenders and use those reports to develop sentences. The Matariki Court is getting great feedback too and seems to be working in the small hamlet of Kaikohe, but it hasn't spread beyond there. So there is innovation in the system, all of it judge-led, but it's limited either as to jurisdiction or as to area of applicability. Section 27 is a section of general application. Anybody has a right to require the judge to consider cultural or social background of an offender before sentencing. Judges tell me it's never used, except in the Matariki courts and the Rangatahi court. Now compare that with the Canadian situation and the famous, at least in Canada, case of the Queen and Gladue, in which the Canadian Supreme Court was applying a provision actually very similar to Section 27. Section 8182E of the Canadian Criminal Code, requiring sentencing courts to consider the principle that all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. With particular attention to the circumstances of Aboriginal offenders. The Supreme Court said every Aboriginal offender must have such a report, now called Gladue reports or Gladue briefs. Why? Because the Supreme Court just came out and said it. The numbers are too bad. Aboriginal incarceration in Canada is too out of whack with their proportion of the population. So we need to know about the background of those people before we go sentencing them to jail. Things like this. The court said these reports were required so as to assess the degree to which systemic and background factors unique to Aboriginal offenders have played a role in the offender's life and the offending. The factors, the court said, will often include poverty, substance abuse, poor education, poor employment opportunities, cultural dislocation, and so on. All, the Canadian Supreme Court said, leading to systemic discrimination that needs to be dealt with and addressed. By contrast, Section 27 in New Zealand is almost a dead letter. To be sure, it's not compulsory. Someone has to ask for one. And it appears one of the problems is that lawyers just aren't asking for them. The impression I get from reading the Canadian cases, there have been a number of cases about Gladue reports since Gladue, is that those reports have changed the way Aboriginal people are sentenced in a very fundamental way. And apart from the Matariki courts and the Rangatahi courts in New Zealand, we are not seeing the same use of that technique to achieve the same change. So, crime has to conclude in that area, crime is a very narrow window of discretion available. But in that area, it seems to me, we are not being creative enough. We are not using the mechanisms that are available enough to achieve the corrections that the Canadian Supreme Court talked about in that context. I was going to talk about IP and public law. I'm not going to accept to say this. Intellectual property law used to be a law in which Māori customary interests were simply irrelevant. So that pharmaceutical companies, for example, could take mātauranga Māori traditional knowledge, and exploit it in pharmaceutical processes and obtain patents and privatise those rights. The Patents Act was amended this year, was reviewed this year, and now contains provisions for a Māori advisory committee. A minor matter, you might say, but the committee can advise the Commissioner of Patents on whether, in the committee's view, mātauranga Māori is being used in any patent application and whether that is appropriate or consistent with Māori values. And the Māori Committee can advise the Commissioner on whether any use of mātauranga Māori, Māori traditional knowledge, or traditional species is inconsistent with the French concept of ordre public, public order. But that's not public order in terms of stopping riots. The French civil law term public order is a very different thing. Whether it's inconsistent with deep values in the community is what ordre public means. So this is a small provision, relatively weak in its impact, but it does open up for the first time the question and therefore the conversation. Just like RMA, just like family law, it's on the table for discussion now. So it is in the Trademarks Act. There's an advisory committee requirement in the Trademarks Act. It's been active now for quite a long while, and I understand with some effect to advise the Commissioner of Trademarks about whether any trademarks may be offensive in terms of tikanga Māori, in terms of Māori custom. Once again, a very weak advisory provision, but for the first time in the IP area, these matters are on the table for discussion. Public law is an interesting one. I don't want to talk about the treaty and all the procedural, consultative and so on requirements that public law would impose when the treaty is relevant. I've already talked about those things. What's more interesting, it seems to me, is what's happening in the Māori world and how that's going to change public law, at least potentially. Because we are seeing the rise of tribal governance entities, operating usually under statute and exercising public power, both within their communities in terms of their members, and in the case of some of these organisations, externally, in the sense of exercising discretions covering conservation estate, waterways, the allocation of environmental use rights. Unquestionably, public law will come to play a part in the work of those governance bodies, whether you call them quasi-tribal governments or not. They're exercising public quasi-governmental power, and public law will have something to say about how those powers are exercised. But the question in my mind is, what will be the role of the first law of Aotearoa in the public law governing those discretions? Will there be a public law concept of kaitiakitanga to sit alongside reasonableness and rationality? How will that play out? Mana is the value or ethic of leadership, the right to make decisions. How will mana speak in the exercise of those public law discretions when the members are complaining about how decisions are being made, or when wider members of the public are complaining about resource consent decisions being made by the tribal organisation? We're not at that place yet, but within a decade we sure will be. And I suspect, at least in a relatively small area, we're going to see develop a new shoot in the category of law we call public law. And it'll be very interesting to see where it goes. Because in that case, custom will strike the second law head on, probably. All right, those are the categories, and I've spoken for long enough, but I wanted to try and pull stuff together and make some sense of all of this. One thing you can say is the map that I've talked about here from the first law to the collision law, the treaty, native title, custom law, fiduciary obligations, and so on, this map is extraordinarily complex and lumpy. Moving into the third law, the law of Aotearoa, New Zealand, you can see the same issues being addressed, the same whanaungatanga issues, the same kaitiakitanga issues being addressed in different categories in entirely different ways. Probably with one side completely unknowing about what the other side is doing. So environmental regulatory controls over whanaungatanga end up being completely different to the approach taken in family law, even though the issue is the same. But the underlying connections remain extraordinarily strong. Why? Because the issues that are being dealt with seem to be the same every time. Whether you're talking about environmental law, family law, criminal law, public law, IP law, or any other kind of law in which there's a Māori dimension, the issues from the first law are the life of whanaungatanga, the life of kaitiakitanga, the place of tapu, the place of mana, and so on. They keep coming up time and time again because they're the core values. The extraordinary thing is they keep getting dealt with in very different ways. The second point I want to make is that this isn't a map at all. Map is the wrong metaphor. This is a system. 3 layers at least. The first law, the second law, and the Aotearoa New Zealand third law, with parts of the first law and the second law bubbling up to the surface, and in that mixing zone, changing stuff and falling back away again. It's like looking at a living archaeological dig in which you uncover old stuff that hasn't been uncovered for a while and discover that it's still alive, still breathing, and still having a significant effect. The next point is, it's clear from looking at the way in which the third law has operated, this hybridised post-1980 system, it's clear that systems struggle to cope. Whether you look at the way in which Resource Management Act mechanisms have failed to be used, Section 33, Heritage Protection Act powers, Section 36B, they're not taken up and they're not working. So it is with cultural reports under Section 27. So it is again in the family law area with cultural reports under the Children and Young Persons and Family Act, Section 187, and under COCA, Care of Children Act, Section 133. Provision for cultural reports there, almost never used, I hear from practitioners, almost never used. So the systems are struggling to cope and work in the demands of this new layer. The next point I think it's worth making, and this is an admission on my part, there is evidence that the judges are failing to cope with understanding what they're dealing with. And that's a serious educational issue in my view. The lack of knowledge of the first law of Aotearoa seems to me is occasionally, not always, but occasionally, a reason why judges are making findings that they are. They're still grappling with the issues and grappling with them in a very judge-like way. But the lack of understanding and education in the first law of Aotearoa is seeing them come up short occasionally. and that's troubling. Finally, it seems to me that the players here, whatever category you're looking at, the players here don't appear to have twigged to the fact that they're engaged in a grand and constant conversation between the executive, the legislature, the judiciary, the tribes, and the wider New Zealand populace. It seems to me few players are seeing what's obvious when you connect all of these dots, that this is a significant period of social change in this area, and there is a grand narrative forming and building. I'll leave you with this question. If the first law is the law of Aotearoa, and the second law, the law of New Zealand, and the third law, the law of Aotearoa New Zealand, is there a fourth law on its way? The law at the point at which these issues are in equilibrium, comfortable with one another and at peace, no longer in tension. In such a context, is it possible to contemplate, probably legislatively, as Matthew Palmer did, the enactment of a generally applicable Treaty of Waitangi Act, making the treaty, giving the treaty the force of law? Is it possible to think of a time when education among the judiciary and the wider community in the first law of Aotearoa is a matter of course and core activity? My pick is that we're heading in that direction, that we are steadily, lumpily, untidily, problematically sometimes, steadily developing towards a time when we can say there is a fourth law of new Aotearoa in which equilibrium is found. Tēnā koutou katoa.